Yes, welcome to the No State Project. I'm your host, Marc Stevens, author of That There Government Indicted, and I'm your host for these 3 hours of Anarchy Radio right here on the Liberty Radio Network. LRN.FM is the place. We are here live most Saturdays from 4 to 7 Eastern Standard Time, 1 to 4 Arizona and West Coast time, rather. And then Sunday morning if you're down under. And good day if you are, mate. So, glad to be back with you here. A lot of stuff going on. A lot of stuff to get to, I guess. Well, we could talk about, I don't know. We'll talk about debunking this garbage, this crap that is spewed forth from people who have a vested interest in ruling you, or a vested interest in the system that rules over you. So, if you're being attacked by a bureaucrat, you want to learn how to defend yourself effectively, number 602. That's from last. That was from another show. No, not that one. We're actually no tech issues yet. That no one's telling me anything yet. But it is 218-632-9399. That's 218-632-9399. Passcode is 2020. You can avoid all that. Well, 2020 to pound sign. Or you can instant message me on Skype at Frank Rizzo 3. Yes, Frank Rizzo 3. And I was finally able to get last Wednesday's show. I don't have just the audio yet. We will post the audio today, but I do have posted on that their YouTube channel. And from that show, yeah, it is video, but mostly it's graphics. Because I don't, you'll see when you see the video. So Calvin did join me in studio. He may join us for a little bit today, which will be fine. But episode 29. I know I screwed that up, and so it's titled "When Crazy Jumps the Shark." And I know I shouldn't be spending time with trolls, but this one, it just. I don't know. We talked about it, so we put the video up. Also good stuff in there. We're talking about proceeding in court and court procedure, and how to effectively defend yourself. So check that out. And, I am going to do a separate video of this, and because it just seems to be that there's no depth of dishonesty to some of the critics. And I bring this up because there are new people all the time, and dissent is more than welcome. We always welcome dissent on the show, but when you flat out lie about the work, that's worse than just a straw man. Just flat out lying, and lawyers have access to material that regular people don't. And when people, send me wins, the documentation to show that they won, most of them will ask me for privacy to redact their names. And I had posted something regarding Gadsden Viper where his wife had a ticket thrown out because I'm so tired of these stupid lies. So I'll just keep posting when someone lies. I'll just show the evidence so that we can discredit them. And so one particular troll likes to say the only times the court has mentioned Marc's motions in a dismissal order, it has called them sophistry, frivolous, and idiotic. And so I posted 2 dismissal orders where the motion was not only granted, but they never mentioned the words idiotic or sophistry or frivolous. And an attorney very, very quickly decided to comment on it. I mean, so I posted it yesterday morning, and then a couple of hours later, there was a response to it. And not only did his name Wesley Serra, not only did this former prosecutor lie about me, but he revealed the woman's real name. Which, come after me all you want. Why violate the woman's privacy by posting her real name? I don't, that's just low, man. My gosh, geez, there was no reason to do that. Wow. So, and I'm going to do a separate video on this because it needs to be on YouTube because I think this nails the coffin shut. Because on its face, it makes me look really, really bad. And so he gives the defendant's name. He says, other than that, the order is accurate. There are, however, one or two minor details that you don't tell your readers. He says, see the M in the docket number? That means misdemeanor. See the AP? That means appeal. In West Virginia, misdemeanor trials are held not in circuit court, whence this order comes, but in magistrate's court. The magistrate on this case was one Michael Gissy. It was to him that you presented your silly motion, and he denied it and convicted her. She appealed. Appeals from the magistrate's court in West Virginia go to circuit court. As both the docket number and the court show, this order is from the appeal. And therefore, when the court dismisses, it doesn't dismiss the underlying case. It dismisses what is before it, the appeal. The defendant gave up, perhaps because of money. Perhaps she finally realized that she was, or you were, meaning me, were wrong. And then he says that I misled people a few weeks ago about an appeal, which I actually posted a correction on. Now, this makes it look like I lied. This makes me look really bad because this is the circuit court, and it was appealed. But when you're a dishonest shill for a criminal organization, you're going to do what's called cherry picking. And what Mr. Serra did, and I'm going to document this on the forum and in an article and a short video. I promise it won't be more than 5 minutes long. It doesn't need to be. Because what he leaves out here is that while it was appealed, if you look under the rules of court for West Virginia, Rule 20.1, subsection D, an appeal of a criminal proceeding tried before a magistrate without a jury shall be by trial de novo in circuit court without a jury. What this lawyer did was leave out, and he had to know this. He had to know this. He has the woman's original name. He probably went on LexisNexis and pulled the docket. He had to know that this was a trial de novo, but he lied. It was a trial de novo, which means you start over. See? In law, the expression trial de novo means a new trial by a different tribunal. De novo is a Latin expression meaning afresh, anew, beginning again. Hence the literal meaning new trial. And the woman's husband, Gadsden, who goes by the name Gadsden Viper on the show and on the forum, and he's in the Skype chat, came on this broadcast and told me about this. I knew it was a new trial. So when you have a trial de novo and you file a motion to dismiss, it's to dismiss the underlying complaint that they're having a new trial for. I can't tell you how disgusting I think that this is. How disgraceful this is. He had to know that this was a new trial. And yet, he cherry picks, he leaves that information out just to make it look like I was withholding information. As if I was lying and Gadsden Viper came on the show and lied that his wife actually withdrew and then the judge wrote did the order. Despicable. Absolutely despicable. This is what you can expect from lawyers. There's a reason why lawyers are the most despised profession on, at least in North America, because of things like this. But we'll talk more about how much we despise lawyers when we get back. Yes, welcome back to the No State Project, where evidence rules. Evidence, logic. not sophistry, not cherry picking. So I was talking about was the compulsive liar, former prosecutor, Wesley Serra, cherry picking, deliberately leaving information out, and then projecting what he's doing, which is mischaracterizing the facts, and accusing me of that. Cherry picking. Let's talk about this disgraceful episode, this latest disgraceful episode from the attorney Wesley Serra. Cherry picking, suppressing evidence, or the fallacy of incomplete evidence is the act of pointing to individual cases or data that seem to confirm a particular position, while ignoring a significant portion of related cases or data that may contradict that position, is a kind of fallacy of selective attention, the most common example of which is the confirmation bias. Cherry-picking may be committed intentionally or unintentionally. This fallacy is a major problem in public debate. Yeah, because it's so damn dishonest. This man went out of his way. I want to paint a picture here, okay? We're not talking about just some jackass on Reddit sitting behind a computer. We're talking about somebody who holds himself as a very, very successful professional. He's not your ordinary troll. The man went out of his way to violate the privacy of somebody, at least in my small little section of the internet, went out of his way to make me look bad, to misrepresent the facts, cherry picking. But what can you see? This is why we say this is one of the times where the public is right. Lawyers are despicable. I know you've got a few good ones here and there, but generally, as a profession, despicable. And it turns my stomach when I have to actually recommend to somebody that they get an attorney because they don't have another choice. They don't have the ability to do public speaking and defend themselves. It's not a matter of they don't understand basic logic. Sure, we do. But not everyone can actually handle the stress of going in, and so I have to tell people you probably should pay someone to do this for you. And that means that you have to go to the monopoly because, of course, lawyers are so good at what they do, they have to have a monopoly to make sure that they have business. Wow. The term is based on the perceived process of harvesting fruit, such as cherries. The picker would be expected to only select the ripest and healthiest fruits. An observer who only sees the selected fruit may thus wrongly conclude that most or even all of the tree's fruit is in likewise good condition. This can also give a false impression of the quality of the fruit, since it is only a sample and not a representative sample. Cherry picking has a negative connotation as it directly suppresses evidence that could lead to a more complete picture. Yeah, exactly. It's always negative. To just pick what fits your narrative. It's like people say, I cherry pick and only present successes on the show, or what appears to be success because I have never had any success anyway. And yet, just on the last show, both callers did not do well in court. They performed well, but they did not meet their objective. So there's no cherry picking here. Cherry picking can be found in many logical fallacies. Well, I'm sorry, a concept sometimes confused with cherry picking is the idea of gathering only the fruit that is easy to harvest while ignoring other fruit that is higher up on the tree and thus more difficult to obtain. Cherry picking can be found in many logical fallacies. For example, the fallacy of anecdotal evidence tends to overlook large amounts of data in favor of that known personally. Selective use of evidence rejects material unfavorable to an argument, while a false dichotomy picks only two options when more are available. See, that is your classic false dichotomy is in court when you go for an arraignment. They think you can have two choices, plead guilty or not guilty. Nolo contendere falls under guilty, so that's why so please, I don't want any. It was dichotomy, Mark, not trichotomy. So, yeah. But when you go to court and they think that you only have the two options, especially when it's traffic, and they say that you have to either plead guilty or not guilty. You have to either ask for a hearing or you have to pay the fine. I'm like, wait a minute. You're neglecting to say that I have, even under your own rules, I have the option to file a motion to dismiss. Of course, you get some clerks that lie and say that you can't do a motion to dismiss. Then how much more evidence do you need of collusion in this rigged system? Cherry picking can refer to the selection of data or data sets, so a study or survey will give desired predictable results, which may be misleading or even completely contrary to reality. Now, I'm going to take a couple minutes here, and I'm going to discuss another example of where this lawyer likes to cherry pick. And they love to bring out the Marc Edwards case, who gave us the documentation from the Internal Revenue Service from Gary Murphy that that the IRS should not take phone calls from me because I have over 24 very embarrassing calls on my website. Embarrassing because they're making claims they cannot support. That's why it's embarrassing, not because they're pitying the retard from Long Island. So what they like to do is point out when like Marc Edwards, who I've never shied away from talking about, and they hold this up as if it is somehow a valid critique or debunking of my material, which consists of challenging your accuser's allegations without accepting a sacred cow, only accepting responsive answers. If that's crazy, I'm guilty. But people with half a brain in their head are going to realize, well, if you're going to defend yourself, you should be attacking the allegations made against you. You should only accept responsive answers, and you should not give them a free pass on any of their allegations. But again, we're talking about lawyers. We're talking about people who are dishonest, who have to cherry pick. And so one of the big things that Wesley Serra and people like that like to do, and again, there's not that many, they don't give you the backstory on what led to Marc Edwards losing his appeal. They don't tell you anything about what happened in the so-called order to show cause hearing. Never going to discuss. All they want to do is what they'll do is they will quote from the order and give you no other information. So they'll talk about sophistry, but they won't actually address the specific facts. They cherry pick and they only discuss what matches their narrative. Really dishonest. We'll be back in just a moment here on the No Stay Project. 218-632-9399 is the number. Yes, welcome back to the No Stay Project here on LRN.FM. And, I got to say something. Maybe this should be a list of reasons why you should not participate in the Free State Project because, you put the commercial makes things sound like it's, I wrote some of the things down. I shouldn't have to because I've heard it so many times. But to me, and I'll get back to Wesley Serra, but, this idea of, the largest libertarian community. Hey, Calvin. Hey, welcome back, Calvin. So the largest libertarian community, the people that feel as passionate and putting your money where your mouth is, and people in New Hampshire are doing something, really? I'll tell you, one of the reasons not to be part of the Free State Project is if you are actually an activist, and I'm talking someone like Ian Freeman, someone like Bill, formerly of the Twin Mountain Country Store. Yeah, I said formerly. Because here, assemblymen, this idea that you can get people elected and that will somehow bring about less of the state. There'll be less aggression in the world. They had an opportunity to help somebody, and the best I could get out of them was a limp-wristed letter. None of them would even make a phone call with me. So if you're going to participate in the Free State Project, you have to know if you're not participating in some 420 event, or it's not, something fairly insignificant like robbing hooding or women being topless, you're not going to get any help. You are on your own. So whatever support system you go there with, that's what you've got. You will be left high and dry by these free staters. And I'm not saying all of them, but in particular, the ones that could have actually done something. Put your money where your mouth is, and it's not just philosophy. The people in New Hampshire are doing something. What the hell are these politicians, these free state politicians doing? They did nothing. They watched as this place burned to the ground and couldn't even make a phone call. And yeah, these are real people. Bill put his whole damn life on the line for liberty in New Hampshire. He was an early mover with the Free State Project. He put his butt on the line. He could have used a little bit of help. Imagine having 5 government state agencies coming after you. And you go against your best judgment. Well, these free states, that's what it's supposed to be about. I'm going to get them. Yeah, couldn't even bother to get off their butt long enough to make a phone call to try to at least relieve some of the attack on this man. It was inhuman how they attacked this man. So keep that in mind. Free State Project is not all, smoking pot and having fun. Well, maybe that's all it really is. I just caught myself because it absolutely is not about sticking by and helping even fellow free staters improve the situation in New Hampshire and bring about more freedom and liberty in New Hampshire, because they had the opportunity to do that, a real life opportunity to do something. Then they failed. Just like Wesley Serra has failed in his miserable attempt to make me look bad. So let's get back to this. Now, what happened with Marc Edwards in Wyoming was an IRS petition, an IRS summons. And this is all the backstory, the cherry picking that people like Wesley Serra will not give you. So always keep that in mind when you're talking to an attorney. More than likely, most of the information, most of the data is not going to be presented to you. He or she will present to you what they want you to hear so that they can separate you from your money. And so part of the backstory here, and I speak from personal first-hand experience and knowledge. They'll even acknowledge, they even posted that my name is on the paperwork. I was there. So they don't tell you is when you get an IRS summons and it goes to court that they want an order to enforce it, they have to file a civil action, a civil complaint, which has to fall within a contract dispute or a tort. And what they describe as sophistry, I had pointed out that as a civil complaint, under Ashcroft versus Iqbal and the Twombly cases, which I'll post, which I've had posted in many of the videos, they say very, very clearly the law here is the basic fundamental principle governing how a court can acquire subject matter jurisdiction is there has to be a justiciable case of controversy. You can't just give legal conclusions and have them be sufficient. The court actually explicitly stated that while legal conclusions may provide the framework for a complaint, they must be supported by factual allegations. We pointed out that Bruce Gilbert didn't have any factual allegations to support most of his legal conclusions. They were just conclusory. Now, these legal conclusions are not just in the complaint. No. There was U.S. Attorney Stephen Sharp. He filed an affidavit of good faith, which you have to do in order to maintain a petition to enforce an IRS summons. The agent who issues the summons has to file an affidavit of good faith. He is making statements under oath, subject to perjury. So, Where is the sophistry there? That the law says you have to have factual allegations. He doesn't. Where's the sophistry? Bruce Gilbert is actually put on the stand over the protest of the judge because Stephen Sharp really wanted him on the stand. And as IRS agents goes, Bruce Gilbert seemed like a pretty decent guy. Bruce Gilbert was declared incompetent to give legal conclusions and make legal determinations. He was impeached by the judge in a fit of anger. Now, have you ever heard that from anyone besides me? If anyone was to see Wesley Serra talking about sophistry and that my position was garbage and legalistic gibberish, that just because the court said that, does that mean it's right? Did they ever address the fact that Bruce Gilbert was declared incompetent? No. I was there. It's in the transcript. It's part of the appeal. But he leaves that out. That's called cherry picking. And it can be found in many logical fallacies. He's suppressing evidence. He's knowingly suppressing evidence to control the narrative. Now, did they ever mention that after the judge declared Bruce Gilbert incompetent to give legal conclusions, did they ever mention that Marc Edwards objected and moved to strike his legal conclusions from the record, including the ones he made in the affidavit of good faith? And that was denied? They never mention that. Why don't they mention that? Because they're cherry picking, because they have a narrative, and that narrative cannot change, and that is because I am dishonest. I mischaracterize the facts. And here is more evidence of Wesley Serra doing that. And anybody who brings out that can say that. They don't mention anything about the actual issues on appeal. They never actually addressed the issues on appeal. They just said everything was sophistry. So let's examine that for a second. I already mentioned that it's absolutely not sophistry and legalistic gibberish to say that the IRS's civil complaint had to have factual allegations supporting the legal conclusions, that the legal conclusions were insufficient. What about the denial of effective cross-examination and taking the testimony of a witness declared incompetent? There's no mention of that. You won't see that in the order because it's so difficult to spin that. So they just say it's sophistry. And these sycophants just keep cheerleading them. We'll be back here on the No State Project in just a moment. The number is 218-632-9399. Yes, welcome back to the No State Project. The number to join the big show, don't be afraid, 218-632-9399, 218-632-9399. The passcode is 2020. And on Skype, which I should have checked already, is Frank Rizzo 3. Frank Rizzo with the number 3. So, let's see, do we have anyone on Skype? And on Skype, instant message me first, so and don't just call during a segment like this. What I was talking about before is this nonsense, or this dishonest tactic that, and it's not just lawyers, it's politicians. A lot of people use this. And yeah, I get sometimes it could be confirmation bias, but when somebody comes out and, like what Wesley Serra does, it's deliberate. They are not doing it just out of confirmation bias. They know what's going on, and they just choose to leave it out because it doesn't support the narrative. Because heaven forbid that they look at the actual backstory and compare what actually happened to the decision of these exalted lawyers that they seem to revere. Well, the court said, black is white, so, black is white. Is it really sophistry to argue that you denied a fair trial or fair hearing because the witness was declared incompetent? And they still took his legal conclusions? Let me look. When an IRS agent says that he has jurisdiction to investigate you and that you're required by law to submit to an audit, those are legal conclusions. They have to be, and so those are legal conclusions which, according to their own rules, must be supported by factual allegations. And the agent that made them is declared incompetent to have done that. Imagine this for a second. We're talking about someone filing an affidavit and the judge actually screaming in a fit of anger that the witness who made the statements on the penalty of perjury is not qualified to make those statements. And who got punished? Marc. Well, he didn't pay anything. He had to appeal, so he had to pay a filing fee and whatnot. But they sanctioned him $6,000 for frivolous arguments, which I've already established are not frivolous. It is not frivolous to contend that a plaintiff has to comply with Rule 12, or Rule 8 rather, the rule of pleadings. That when the Supreme Court says you got to have factual allegations to support your conclusory statements, that conclusory statements are not sufficient. The man got sanctioned $6,000 for making an argument based on the rule itself. Of course, he had the evidence to back it up. He had the complaint. He was able to show the statements were conclusory in nature and didn't have any factual support. How is it then sophistry or a frivolous argument to claim that you were denied a fair hearing because the judge denied effective cross-examination? Look, if you're going to keep the testimony of Bruce Gilbert or the IRS agent, if you're going to keep the testimony on the record, you have to allow confrontation, which the judge didn't. How is it sophistry to point out that you could be wrong? That doesn't mean it was sophistry. It doesn't mean it was frivolous. Frivolous doesn't mean it's wrong. It's so wrong, it requires no demonstration. But that's not what we have here. You have a judge, by his own ruling, declared the witness incompetent and still allowed the testimony and refused to allow cross-examination after that. And you have the standard, if there was a denial, if there was here a denial of cross-examination without waiver, it would be a constitutional error of the first magnitude, and no amount of showing of want of prejudice could cure it. This concession is properly made. The Sixth Amendment provides that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. It's just pretty standard stuff. How is it frivolous to argue you were denied effective cross? Even if you weren't, they have to go into the record and actually demonstrate. The opposing counsel has to demonstrate that you were not denied, that the judge had a valid reason not to allow cross-examination. That they have to show that the judge limited the cross-examination to relevant issues. Well, how are the statements in the prior testimony of the IRS agent, how is that irrelevant? It's all relevant. It goes to competency and credibility, and Marc thoroughly impeached the witness according to the judge. How the hell could you possibly logically and rationally and honestly try to argue that my position that Marc Edwards was denied effective cross-examination how could you possibly say that that's frivolous? Yes, the judges did, but does that mean that they're right? You have to look and see if what was presented by both sides, does that support the decision of the judge? Is it really sophistry? Well, let's look at what happened. Is it idiotic? Only in the sense that you thought you were going to get any kind of justice and fairness from these lawyers. So maybe in that sense, but the arguments weren't frivolous. The arguments weren't idiotic. The arguments weren't sophistry. A denial of cross-examination without waiver is a constitutional error of the first magnitude. No amount of showing of want of prejudice could cure it. You just have to show what happened. But they won't address they won't address it. Now, some do. Now, here the Court of Appeals just turned a blind eye. They just rubber stamped it. No, there was no discussion. There was no analyzing the issue. Nothing. Just frivolous. The frivolous rubber stamp. Because when they do discuss it, you get like what Patricia Starr did in Phoenix, Arizona. She just flat out lied and said it was a proper objection. Even though Rebecca was asking for the facts, she lied and said, well, it calls for a legal conclusion. Instead of saying, look, the prosecution made an improper objection. The judge had no business granting it. She was denied effective cross-examination. This has got to be reversed. But lawyers like Wesley are not in the business of justice and fairness. How many times we got to say this? The courts have ruled that due process requires notice and opportunity to defend, and that a hearing must be done in a meaningful manner. And if it wasn't meaningful, it doesn't matter if the appellate court rubber stamps the trial court's egregious violations. And yes, the courts are wrong a lot of times. And it's like, why would anybody give so much credibility to these lawyers? Because it fits the narrative here. If it goes against their narrative, they'll probably, complain bitterly also about these judges, or at least about the ruling. But it doesn't fit the narrative. And that's what is important here. This is why we've said so many times, we know how they operate. People like Wesley Serra are not looking at all the data and then drawing a logical conclusion or plausible conclusions from the data. They're taking they make up their mind first, and they'll say, anyone who challenges the IRS is an idiot and wrong, and so any data that goes against that narrative is cherry-picked out. They just leave it out, like what Wes did here and with Marc Edwards and the disgraceful thing he did on my forum. Absolutely disgraceful. There's two ways about it. So cherry-picking, yeah. Is it a problem? It's always a problem. Let's see what we got here. Choosing to make, this is Richard Somerville, testimony before the U.S. House of Representatives back in 2011. Choosing to make selective choices among competing evidence so as to emphasize those results that support a given position while ignoring or dismissing any findings that do not support it is a practice known as cherry-picking and is a hallmark of poor science or pseudoscience. Stephen Vellis says, rigorous science looks at all the evidence rather than in cherry-picking only favorable. Controls for variables as to identify what is actually working, uses blinded observation so as to minimize the effects of bias, and uses internally consistent logic. And that's the thing, when you're looking for the truth instead of just putting forth a particular narrative. In argumentation, the practice of quote mining is a form of cherry-picking in which the debater selectively picks some quote supporting a position or exaggerating an opposing position while ignoring those that moderate the original quote or put it into a different context. It's a bad problem, and you have to be aware that this is what's going to happen when you deal with these killers, thieves, and liars, these lawyers. But we'll be back with the second hour of the No State Project in just a moment. Don't go away. Yes, welcome to the No State Project here on LRN.FM, the Liberty Radio Network. Second of 3 hours of Anarchy Radio here on LRN.FM. And for those who get the podcast, I guess about 45 minutes through essentially about 2 hours of content. So, but anyway, I don't know why I mentioned that. But if you want to join the show, it's 218-632-9399, 218-632-9399. The passcode is 2020 with the pound sign. And, of course, you got that there Skype, which is Frank Grizzle 3. I'm talking about just despicable lawyer tactics, what you can expect when you're dealing with lawyers or people making false claims, and how cherry-picking is particularly despicable because, like he says here, this is from Wikipedia, by the way, for cherry-picking. Cherry-picking in debates is a large problem as the facts themselves are true, but need to be put in context. That's not necessarily what Wes was doing. Not much was very true in what he was saying. He just suppressed evidence for a different narrative. But cherry-picking, you can present just the facts that are favorable to a position, of course. Cherry-picking debates is a large problem as the facts themselves are true but need to put in context. Because research cannot be done live and is often untimely, cherry-picked facts or quotes usually stick in the public mainstream and, even when corrected, lead to widespread misrepresentation of groups targeted. The one-sided argument, also known as card stacking, stacking the deck, ignoring the counter-evidence, slanting or suppressed evidence, is an informal fallacy that occurs only when the reasons supporting a proposition are supplied, while all reasons opposing it are omitted. Pete Suber has written, the one-sidedness fallacy does not make an argument invalid. It may not even make the argument unsound. The fallacy consists in persuading readers and perhaps ourselves that we have said enough to tilt a scale of evidence and therefore enough to justify a judgment. If we have been one-sided, though, then we haven't yet said enough to justify a judgment. The arguments on the other side may be stronger than our own. We won't know until we examine them. So this isn't even a problem with what we're doing with Wes. He's just leaving the evidence out so we can put out a false narrative. Card stacking is a propaganda technique that seeks to manipulate audience perception of an issue by emphasizing one side and repressing another. Such emphasis may be achieved through media bias or through the use of one-sided testimonials or simply censoring the voices of critics. The technique is commonly used in persuasive speeches by political candidates to discredit their opponents and to make themselves look more worthy. The term originates from the magician's gimmick of stacking the deck, which involves presenting a deck of cards that appears to have been randomly shuffled, which is, in fact, stacked in a specific order. The magician knows the order and is able to control the outcome of the trick. In poker, cards can be stacked so that certain hands are dealt to certain players. The phenomenon can be applied to any subject and has wide applications, and it is particularly perverse in the legal profession. How many times have we reported on the show about Brady violations? Brady violations are an example of cherry picking that cost people their lives, sometimes literally. How many times have we read and seen Kaczynski saying it's at epidemic levels? Someone who has, as long as the IRS is the one guilty of the cherry picking, he's fine with it. He's fine with Brady violations there. But epidemic levels. So when a prosecutor who bears the burden of proof has evidence, has data, has information that shows that you are innocent, they're supposed to give it to you. Not only give it to you, they should think twice about prosecuting you. If there's evidence that you're innocent or that seriously impeaches the prosecution's case, then they should withdraw until such a time as they have sufficient evidence. But we're not talking about honest people here, are we? No, we're not. So we have Judge Kaczynski, who gave a laundry list of cases involving rampant prosecutorial misconduct. That is a horrible example of what we're talking about, of cherry picking. Deliberately, just like what, and this is what gets me. And, we put up a pledge drive for Wes, and we got less than 30 cents. Nobody wants to hear him. He wanted $20,000 to come on the show. Yeah, good luck getting anyone to pay you $20,000 to hear you talk. Wes is a former prosecutor. So, look, if this lawyer is willing to sink to such despicable lengths to try to show that I'm a bad guy on the internet, my gosh, what does that say about what he did when he was a prosecutor? I would suggest that all his cases should be examined. I mean, it's not that big a logical jump there. I mean, seriously. If he's going to do that to me on the internet, why wouldn't he have done it to someone he was prosecuting? I wouldn't doubt for a second that Wesley Serra has got some serious due process and Brady violations under his belt. Of course, he wouldn't be able to see them, but they, metaphorically, So for those who aren't aware, get a little more specific here. Brady disclosure, Brady material, consists of exculpatory or impeaching information and evidence that is material to the guilt or innocence or to the punishment of a defendant. The term comes from the U.S. Supreme Court case Brady v. Maryland, in which the Supreme Court ruled that suppression by the prosecution of evidence favorable to a defendant who has requested it violates due process. Following Brady, the prosecutor must disclose evidence or information that would prove the innocence of the defendant or would enable the defense to more effectively impeach the credibility of government witnesses. Evidence that would serve to reduce the defendant's sentence must also be disclosed by the prosecution. In practice, this doctrine has often proved difficult to enforce. Some states have established their own laws to try to strengthen enforcement against prosecutorial misconduct in this area. So the Brady Doctrine is a pretrial discovery rule that was established by the Supreme Court. The rule requires that the prosecution must turn over all exculpatory evidence to the defendant in a criminal case. Exculpatory evidence is evidence that might exonerate the defendant. Well, we know that Wesley Serra has, against me, in his years-long campaign to discredit me, is, aside from the ad hominems, is a well-established pattern of cherry-picking. I don't think he developed it as an old man. I don't think this is a new thing for him. I think this is probably something he's been doing since he was a young prosecutor. And I don't doubt that there are people whose lives have been destroyed by this man. Again, what does he have to gain from cherry-picking and lying about me? He's got a lot to gain as a prosecutor, though, because he ramps up his convictions. And we know that they do it. Judge Kaczynski said, it is a long list, like I said. We know they do it. It's at epidemic proportions. So, yeah, maybe somebody, there should be an investigation into his prosecuting career and see just how many times he may have cherry-picked some poor soul in his quest to get more prosecutions. Just despicable. This is just, it's so petty. My gosh, to try to win an argument online, to lie to such an extent and reveal someone's name? Give me a break. All right, we'll be back here on the No State Project. You want to join me, it's 218-632-9399. Passcode is 2020. Yes, welcome back to the No State Project. I'm Marc Stevens. Been listening to 3 hours of Anarchy Radio right here on the Liberty Radio Network, LRN.FN, baby. And we're going to take a little break from the cherry-picking Wesley Serra. He couldn't even raise 30 cents to have him come on the show. And the thing is, and he's been on the show before. Welcome back, Gabe.
Hey, Mark.
Hey, there he is.
So I want to talk about a few different topics real quick. Firstly, the topic of appealable errors that would result in a reversal rather than a new trial.
Okay.
So I was wondering if you had a list off the top of your head of points that would be strongest. For example, the only ones I'm aware of so far is a lack of evidence. So either a lack of evidence from the cop or, on the topic of what we talk about, a lack of evidence establishing jurisdiction. And I plan to make this the main focus of my appeal and maybe mention all the other issues and ethical violations that they did. But I figured you would be more experienced with knowing which ones would be reversal versus new trial?
I believe, and I'd have to look it up to know for sure, but I believe it tends to be at the discretion of the trial court or the prosecution if there's going to be a new trial, if it's reversed.
Is that right? I thought that it would go to the state court of appeals, and then they would decide if it was going to be reversed or set for new trial at the same court.
They can. That doesn't mean a new trial will be carried out. The prosecution can decline to re-prosecute.
Right. And this is really crazy how like open and liberal they let the interpretation of this thing be. As much as the Supreme Court has spoken against, all these ethical violations of the lower courts, they've brought up the issue of jurisdiction, and they've also brought up the issue of these traffic tickets where they balloon from like $1,000 and you get on a payment, or from like $100 and you get on a payment plan and it balloons to like $1,000, and the higher courts have smacked the lower courts on the hand, and they kind of dialed it back a little. And yeah, every day I wake up and just think about how much of a joke it is, and how we're just seeing the just the Matrix, all these people walking around blinded while you're walking around wearing these glasses from the movie They Live.
Which is a great movie, by the way, if no one's seen it. So if you haven't seen it, check out They Live today, after the show. So, yeah. Well,
yeah.
It would come. That's why it's very easy for people like this recent troll on the forum to gaslight you, because you've looked at the data, you've looked at the evidence, and without any sugarcoating, without any legalese, you see them for what they are. You know that you cannot look if you can put, what is it? You could put a wig on a pig; it's still a pig. You can say that it's a sovereign entity that the people have agreed to, but that doesn't negate the facts. The facts are that nobody was given a choice. So you're seeing that, and the whole thing collapses. And so you get these trolls in there who the only defense they have is an insult and gaslighting you to say, are you crazy? That's why when you see, like, I have the actual comment in the video about the metaphor stuff, it's insult after insult after insult. I'm just too retarded to understand his brilliance. That's what it comes down to. And it's because people are buying into this, and we're walking around and not accepting the sacred cows, and so it is easy for them to gaslight us if you let them. And that's what, it's going to happen in court. They'll laugh, they'll mock, and they'll do anything but give any actual evidence to support their claim.
Mm-hmm. No, in court it is one thing, but as far as critics on the internet, I hope that you don't take it personally or even seriously. When I first came across your material, I was knee-deep in free man on the land, sovereign citizen, and I was studying this stuff because I just fell into that rabbit hole while studying how to fight tickets. And then I came across your How to Beat a Civil Traffic Ticket Part 2, I think. And I watched that thing and I saved it. And then about a month later, I watched it again, and I saved it. And about a month later, I watched it again. And then I watched it like 3 times in a row. And then I watched your video with that guy with the purple background and the mullet and the cheesy music. And I watched that thing. I downloaded that thing and put it on my phone, which was an old dumb phone. And I watched it over and over and over and over. And it finally started sinking in. So, I mean, again, this is what I meant by, I hope you're not taking it personally or seriously, because some people, it takes them a while to wrap their mind around it.
Yeah, I don't. Honestly, what gets to me is, like what I mentioned about the Free State Project earlier, to have people, and I have to listen to it. here on the network to have people just advertising. And Calvin's here. Say hi.
Hey, what's going on?
Yeah, we got Gabe on. Because you know how I feel about advertising.
Yeah.
And to hear them and know that we reached out to them and they did nothing. That's what bothers me. What bothers me is when good people are hurt. Like a doctor, I won't mention the name, a well-known physician, libertarian, anarchist type in Missouri, to actually hear about how the prosecution was so cruel. That bothers me. But criticism, no. Especially if it's honest criticism, that's great. It does get a little under my skin when people are so rabid about making me look bad. And they will go through the lengths that they do, like Wesley Serra. This man deliberately left out data to make it look like I was a shyster. So, and the thing is, I have to give him kudos on this one, Gabe. He did a damn good job. The initial impression is like, oh my gosh, this makes me look like a criminal. So your mind swims from, and then you're like, well, wait a minute. There was a new trial. There was a new trial. It was a trial de novo. Duh. He's lying. So we're up against the break. So you just hold tight. My name is Marc Stevens. Calvin's joining me for a bit, and we've got Gabe on. We're going to be discussing appealable errors. We'll also take your calls at 218-632-9399 in just a moment. So don't go away. Yes, welcome back to the No State Project. Joining me again here is Calvin. We probably got to get you a little closer here, so it's not on video, so we won't get all the...
Hey, I go holler. I got projection.
You were out before when I was talking about cherry picking, and but now we got Gabe on. We'll bring him back in a second. I can't get away from how despicable that was. That come after me, fine, but to reveal the woman's name, what a
douchebag move, I think is the term.
Yeah, and
but then again, we're talking about a former prosecutor, so shall we expect less?
Yeah, a former prosecutor these people are known for ruining people's lives. There's one former prosecutor. I don't know if Gabe, if you've heard of this, but he's a judge in Texas. He actually got prosecuted. Well, they charged him. Because an innocent man went to prison. He knew he was innocent. He went to prison for 20-something years. All this guy did was lose his law license and go to... And I don't think he did any time.
Yeah, but that's still a pretty harsh punishment for one of their own.
Oh, good.
You must really piss someone off to get that heavy of a sentence.
Yeah, I know. Oh, his law license. Like Bill Clinton, he lost his law license. Big deal. He never used it. So, Gabe, I think... somebody out there, who knows better, I've looked up about reversible errors. I might have to look more into this. I've always been under the impression that if it's reversible, then it's up to the court whether they're going to order a new trial or not. And if they do order a new trial, it's up to the prosecution if they want to go ahead and prosecute you again.
Right. Yeah, I was hoping you would have a more definite answer on that. I'll have to look up in the codes, not that I agree with their codes, but just to see if they say specifically, because I wasn't able to find it so far.
Well, we'll have to keep looking. I know, like, a list of reversible errors here on Wikipedia is seating a juror who has manifested impermissible bias to one party or the other, admitting evidence which should evidence which should have been excluded under the rules of evidence, excluding evidence which a party was entitled to have admitted, that's your cherry picking, giving an incorrect legal instruction to a jury, that is a huge one. I will tell you that the law applies. Don't listen to whether, the prosecution proved it or not. Failure to declare a mistrial when continuing with trial amounts to a denial of due process. Or conversely, granting a mistrial in a criminal case if the defendant objects unless the grant was necessary to correct manifest injustice. It says here, if an appellate court determines that reversible error occurred, it may reverse the judgment of the lower court and order a new trial on such terms and conditions as are found to be just. I could be wrong. I don't think it's anything other than the discretion of the appeals court on what they're going to do, whether outright reversal, and that might depend on just how bad things were done. They may, if it shows that you have exculpatory evidence that shows you are clearly innocent, I don't think they're going to order a new trial. if you have a situation too, if we have a situation, I can try to get that right. If we have a situation where the only witness against you has been declared incompetent, how could they order a new trial when the only witness is not competent to testify? So I think in that situation, I think that the court would not just reverse it, but they would have to just throw the whole thing out completely because the prosecution is out of witnesses.
No case.
Mm-hmm.
So,
and that is sorry, go ahead.
All right, so that's why I think that's why it hinges on the discretion of the court and just how serious the error was. Because I think if it has to be an error that's so bad that a new trial can't cure it. And so a lack of evidence, like you mentioned before, or not having a qualified witness, that would be sufficient, I think, to show, look, a new trial cannot cure this. And that would be, so that would be what we're, and so I think that really hinges on, some of the errors that we're looking at. So when someone goes for there's a jury trial, the denial of a voir dire. Now, that's reversible, but that doesn't necessarily mean that they're not going to order a new trial where they say you have to, with instructions, you damn well better give this man a voir dire. Because if you deny it, contempt and all that. I wish I had more for you, but I think that's really the nuts and bolts of it.
Right. No, that's good. I mean, I'm asking you to interpret their muddy water. It's ridiculous. So, but yeah, I mean, I've been in front of 5 different judges in that courthouse.
Oh.
And if they were to send it back, I know there's no way that I'm going to get a fair, meaningful hearing. That'd just be delusional for me to expect that.
Well, I'll give you an example that we went through, where in New Hampshire they refused to give Bill discovery, and they were not going to allow Bill to confront any of the witnesses against him. So that's typical, especially if it's IRS. But this was not. This was a state agency and not a tax agency. But we went to lead counsel for the NHES, Maria Del Terrio, and she did the right thing. She said, oh, no, you will conduct a hearing with the witnesses that the prosecution relies on. You will allow cross-examination, and you will give them pre-hearing discovery. But we didn't get the pre-hearing discovery.
Yeah, and that falls right under the denial of due process. You have the right to confront your witnesses, and what we're looking at here is failure to declare a mistrial when continuing with a trial amounts to a denial of due process. So
that's
it's kind of a big one.
Well, that's one that I immediately think of Kicking the Dragon, which is right back there, by the way.
Yeah, it's a good read.
Where the judge stated that he believed that Larkin was sincere in his belief that he was not required to pay taxes. Letting it go further, it should. Well, I don't know if it's necessarily a mistrial, but the judge should have stopped it right then and there. You cannot show reasonable. I mean, you cannot prove beyond a reasonable doubt. The man was sincere. So, but of course, he gave it off to the jury because that's what his job is to do. Criminal. So it's not necessarily that I'm trying to look. I put myself out there as knowing a bit about the legal system. I'm not an expert. And there are certain issues that, like this one, I'm not absolutely certain, but I'm pretty confident in that it's up to the discretion of the appellate court that's making the determination to review whether they're going to order a new trial or not. And again, like we mentioned before, it depends on what the error is. If a new trial can cure the problem, then they'll order a new trial. And then it still hinges on the prosecution could be like, I don't want this again, and so they let it go.
Right. Yeah, it's very open to interpretation, however the judges would say it.
Yeah.
And I was thinking about earlier when you brought up the $25,000 fine for bringing up frivolous arguments, how you could use softballs to at least try to set it up to avoid a frivolous argument fine. Would it be a frivolous argument if I was just asking for clarifications to get informed? Do I have the right to ask clarifications on this specific topic as to whether or not the prosecutor has met their burden on it.
If you're in the tax court, you cannot avoid if you're challenging underlying liability, you cannot avoid the frivolous penalty in the tax court, the U.S. tax court. That's a done deal.
No matter how you...
It doesn't matter. We had one where I've said it before. All they did was they had no evidence against the husband. Admittedly, no evidence. The agent's name was Donaldson. I have the recording. I was the one he said it to. I have how many calls of shames? I talked to the IRS a lot, and so Donaldson was just one of hundreds, and because they had no evidence, and it was so obvious they didn't because we had his admission on the record, they took the husband's name off and copied and pasted in the wife's name. And the tax court still found against them and fined them. So another thing, too, you can't even withdraw from the tax court without a permanent judgment against you. So it's bad. But we'll talk about that and more of these appealable errors when we get back in just a moment. So please don't go away. Yes, welcome back to the No State Project. Glad to be with you here on this beautiful August 12th, Saturday, for 3 hours of Anarchy Radio. And we are taking calls. Yeah. 218-632-9399. It's 218-632-9399. The passcode is 2020. We're also taking Skype calls like we have with Gabe right now. Gabe, welcome back to the show.
Hey, Mark.
Hey, Calvin, can you update and remind everybody just what kind of proceedings you're going through?
I've helped some family members with some stuff. The last thing I fought was a traffic ticket for, I can't remember if it was speeding or something like that, but then my most recent situation was a DUI accusation, which, they don't feel the need to present evidence, even if you were to argue just the merits. But the more important thing, obviously, is, there's so many people coming in who say, I'm actually glad I got this ticket because it caused me to find this group and to get red-pilled in the process.
Right. So so you've been convicted, and are you in the process of appealing?
Right.
So when is your brief due, or have you done that yet?
No, I'm working on it. I want to keep it as short as possible. So I need to buckle down and get working on it more.
Well, what I would suggest is for everybody too, the errors that you're raising should all be reversible. They should at least send it back for a new trial, all on their own.
Mm-hmm.
And
you want to stack them seems to be the big determining factor.
You want to stack them?
Well, you want to make it clear that they had no intention of giving you a fair, meaningful hearing. Seems to be what sways them is the feels more than the facts.
Well, I think, and you can get there, if that's true, you get there by showing the pattern that the judge is. That's why we talk so much about the judge carrying the prosecution's burden, that he did not presume you innocent, because if he presumed you innocent, he would have held the prosecution to their prima facie burden. He would not have made excuses that he's not required to prove that. He would not make excuses saying jurisdiction's a trial issue or jurisdiction's a pure issue of law. The only evidence they need is that you're physically in, was it Edmonton or is it Alberta?
Me?
Yeah.
Oregon.
Oh, how the hell did I screw that up? Okay, all right. I think I remember now. Okay. Who the hell? Wow. Okay. Never. Okay. So, yeah, because physically in Oregon, this is a pattern of abuse, especially if you have a situation where you try to plead guilty. If the prosecution had met their prima facie burden and the judge wound up yelling and screaming and whatnot, or just getting upset and entering a plea of not guilty for you, like continually covering for the prosecution. It's something we can show. The denial of due process, because of the denial of a fair trial, because he did not allow. He allowed the prosecutor to argue without evidence, and they denied you effective cross-examination. Those are all to protect the prosecutor. It's an ongoing, from the very start, they have been working actively on behalf of the prosecution. So all that adds to the, if you want to call it stacking, it's fine. Yeah, I just look at it more as you're showing a pattern of abuse.
Mm-hmm.
It's not isolated.
Well, they have no shyness in stacking their violations high.
No, are you actually near Robbie?
I used to be. I think he'd be about 8 hours away from Southern Oregon.
Holy crap! I thought he was in Oregon, though.
Yeah, he's in Northern Oregon, so we're on opposite ends of the so-called state.
It's an 8-hour drive across Oregon.
I believe so, to take the roads to get from my place to his.
Oh, okay. All right, man. Because, wow.
I might be wrong about that. I looked it up on Google about a year ago. So.
Oh, all right. No, okay.
Mm-hmm.
Well, so what particular issues, are you planning on putting in the brief?
I'd like to start and mainly just base it off of the lack of evidence establishing jurisdiction, and use that as basically the only thing they could grant it or reverse it on would be lack of evidence establishing jurisdiction, just to see if they'll do that. And I could throw in as many appealable errors as I can list, because every single one of them of these ethical requirements was denied.
Okay, and so you probably have a pretty serious Brady violation also. That's just standard. Mm-hmm. Okay, and then you, as far as the cross-examination of the police officer, did they do the standard line that you're asking for evidence to support his claim that the laws apply because you're physically in Oregon, and did they object and on grounds that it called for legal conclusion? And did it happen that way?
I'm trying to remember. I think that I got pretty close to that. I think it was right around that time when I was starting to get into the cross exam, the most important part. I think I was just starting to get into, you determined on your own that the code was applicable and that I violated it. And then getting into also how many elements in a valid cause of action. And I think it was right when I first started getting into it that the judge shut me down. So I don't know if I got anything super effective that goes toward that specifically.
Did the judge allow you to ask questions regarding the evidence the cop rely on to prove that the code applied to you?
No, absolutely not.
That's a denial of effective cross-examination. As I mentioned earlier, Brookhart versus Janus is the citation. Let me read that into the record. 384 U.S. page 1. And the actual quote, denial of cross-examination without waiver is a constitutional error of the first magnitude, and no amount of showing of want or prejudice will cure it, is on page 4, I believe, of that. But Brookhart versus Janus, 384 U.S. page 1, and I have it linked all over, on a lot of the recent articles, and it's in a lot of the recent videos. So that is huge. If that's the only issue you raised, if they addressed it, would reverse the whole thing. Now, they may issue a reversal order saying that you have to put a fair trial on, which includes you have to allow this man to cross-examine a police officer effectively. No, but if you put in there that there's a Brady violation and that the prosecutor deliberately put an unqualified witness on a stand, then that might be enough for them to say, well, the witness is obviously not credible. We have a serious Brady violation, and they'll just reverse it without an order for a new trial.
And that really does help build the case if you're not effective at making the point that the cop made the determination on his own and he doesn't know how many elements would be required for a valid cause of action. Having it in the discovery and Brady, putting the burden again on the prosecutor's shoulders, really helps to build the case if you want to bring up that unqualified witness at appeal. I think I was allowed to ask about 4, maybe 5 questions of the cop.
Gee.
And every time I was on point, and the judge would just jump in and just threaten me with violence and shut me down.
Yeah.
And that was pretty typical. And I kept bringing it out in front of the jury. Like, every time you guys go in sequestered into your room, this guy's threatening me and telling me that if I make motions or objections that he doesn't like, then every time he's writing it down and he's saying he's going to add more time in contempt once the jury leaves. Like, are you guys aware of this?
Wow.
Judge, is this stuff that the jury is allowed to know or not?
Well, we're up against a break here. Hold on. So you told the jury about contempt. I want to get back to that because we're at the top of the hour break. So you just hold tight, Gabe. My name is Marc Stevens. You're listening to the No State Project. We're going to be back with Gabe and Judge, just like with Mike, threatening without the jury present. We'll be back in just a moment. Yes, welcome to the third of 3 hours of Anarchy Radio here on the LRN.FM. I'm your host, Marc Stevens. Website is marcstevens.net. Remember, anarchy is just an absence of rulers. What we do is we live our lives as more consistent, and we believe that the basic principles of right and wrong apply to everybody. And that's, Calvin and I talked about this morning. It should be really easy to convince people that anarchy is the most rational way to live our lives and it doesn't take, days to convince, people either accept it or they just reject it because they've, confirmation bias, or they just have a vested interest in the system. And it's very simple. You ask, do you believe in basic principles of right and wrong? That, do no harm and that we should treat others, with the respect and the way we want to be treated? Well, yeah. Do you believe those rules should apply to everyone? Well, yeah. Welcome to anarchy, because that's all we believe. We believe that the rules should apply to everybody and that we reject the double standard, that it's okay to hurt others if you call yourself a government or a sovereign entity. Yeah, forgot, yeah. I know it's a metaphor. Some people think they're real. Whatever. But that's what we're talking about with anarchy. So I want to welcome back to the show Gabe in Oregon. And because this is interesting, because I know that Mike was not able to do that in his tax evasion trial a few years ago because the judge would have put him in jail immediately if he mentioned the threats. You were able to mention the threats to the jury and the judge didn't, and the prosecutor didn't say anything?
The judge would make additional threats and, say that I was getting closer to contempt. And even at one point after I finally had to ask, exactly how and when did I become somebody's slave, then the judge finally, that I cannot abide in front of the jury, that you are in contempt now.
Oh, please. I evaded these people. Wow. So I don't remember, did you do any time?
Not for that. He went into his chambers for about 5 minutes and maybe 10. And I got a hold of the guys on the Skype chat. And I think there was at least 3 people calling in and asking the clerks downstairs as well as the judge's assistant, what what was going on. Like, why are they threatening to put me in a cage absent this evidence of jurisdiction? And I think that might have been what made the difference between him throwing me in a cage pre-sentencing and letting me go.
Wow. Well, it might be. It might be. There's, the circumstantial evidence supports that, but we don't know for sure. So kudos on the guys for doing that. Wow. Okay, so that's obviously something that you want to put in there. How hostile the judge was. Do you know the name? What's the name of the judge? Do you remember?
I'll have to send that to you later.
Yeah, I'd like to be able to.
Timothy Barnack in Southern Oregon, I believe.
Timothy?
Right.
Barnack. I'll look that up. So if we can get a picture of this guy, we'll put it in the video and in the show notes. Timothy.
Yeah, I mean, I don't think that any other judge was any friendlier. So of all the idiots in the room, as the quote goes, he was the brightest, which I guess is kind of fortunate. Because, again, I've been threatened by every judge in there except for one, and that was the one that I asked if he was going to become comporting himself in accordance with the rules in the Judicial Code of Conduct. But the main, if you don't mind me shifting the topic real quick, I wanted to discuss the number one red herring. Not only when a judge is blocking you from getting this information from the prosecutor, but as well as when you're talking to a appellate attorney and they don't want to challenge the issue of jurisdiction based on physical location and the lack of evidence submitted by the prosecutor. So what we commonly hear from this red herring from a judge is that, the cop's testimony is all we need, that you were physically here, and that's all we need. If you were physically here, then the code's applicable. They may throw in because the code says so, or they may not. And these are just, no amount of words can turn these red herrings into evidence that makes that conclusory statement and non sequitur become true. And then the way that a appellate lawyer would phrase it is that they took a oath to only challenge meritorious issues, and that this is not a meritorious issue because they have jurisdiction, because the cop said you were here and the cop swore to it, and when he swears to it, it becomes evidence. Yada yada, and it's just meaningless drivel. So I want to hear your thoughts on that.
Well, it's kind of standard. So you made the objection. How does my physical location prove the Constitution applies to me? Can you explain that? And he's saying that's what he's saying, that the cop's testimony that you were here. Well, objection. How does my physical location prove the Constitution applies? I know the cop said that. Okay. That's how I handle it.
And we're going to respond. Well, again, you were physically here, were you not? And so the cop swore that you were physically here, and that's all we need. And that's the rules. I understand that you don't like it, but we're only going to allow meritorious issues.
Well, it's still an issue on appeal. I mean, for cross-examination, which he denied you because it is prior statements of the cop. It's right on the ticket. So,
right.
So to not allow you to question.
I was trying to engage in a little bit of role play.
Oh, I'm sorry. Sorry.
Because they just hammer you with this same red herring fallacy over and over. They just hammer you over and over.
Yeah.
Like, you're crazy. You need a psych eval. Look, the evidence is that the cop swore you were physically here, and that's all we need. If you were physically here, then the code's applicable.
So you could say, well, objection. So my physical location means that a written instrument from 1879 applies to me?
Look, I don't care how you want to interpret it. Yes, the state constitution is from 1879, but unfortunately, as much as you dislike it, the cop swore that you were physically here, and this code is applicable to anybody that is physically here.
Objection, but what evidence proves that? And I'll let you know it's something that's supposed to be given to me in discovery, and I will cross-examine the police officer on that. If they're going to do that, if they're that adamant, the only chance we have is to get on cross-examination and have them deny cross, because now you've got a guy who's dead set against you, and he's going to use these fallacies, these fallacious reasons against you. So there's not much if anything, we can do in that situation. And we can move to we can file to remove the judge, but you went through 5 of them, and so the only option may be like what you're going through now is you bring it up on cross. You have them declare the witness incompetent after they've already said that the cop's testimony is sufficient. Because, I mean, look, that's the practical nature of that. That's all we can do. If the judge is going to say the cop's testimony is it, and then he's not going to allow you to cross-examine him or make up some story that the cop is not qualified to give such legal determinations, the best we can do is hope that those errors are sufficiently bad that they will reverse it on appeal.
And we know, of course, that the crux of the issue is that the cop made the first accusation, and that for him to do that, he made the determination that the code was applicable based on no evidence whatsoever.
Right. Well, hold on. We are up against the break, so just hold tight on that. And I actually have some video footage of this judge. We'll be back with the No State Project in just a moment. Don't go away. Yeah. There's actually a YouTube video where he got reprimanded, so I want to play that when we come back. Cool. Yes, welcome back to this here No State Project on LRN.FM. We're talking with Gabe in Oregon, and there's actually a news report about the judge, Timothy Barnack, and I wish there was something else that I could provide over here, because I got to tell you guys in advance, I was just telling Calvinist, I agree with what the judge said. I think in this instance, Timothy got it right. I don't agree with him being reprimanded for that. I think he should be reprimanded for threatening someone like Gabe and denying, openly denying, somebody an effective cross-examination. To turn around and say, all we need is the police officer's testimony, and then say, we're not going to allow you to question him on that. Oh, come on. But so just hold tight a second, Gabe. I don't know if you've ever heard this or not. I have not heard this. I didn't preview this, but it's about a minute and a half long. So here we go. Come on.
The Oregon Supreme Court censured Judge Barnack. A censure is a formal document stating Judge Barnack crossed the line in the courtroom. The state of Oregon has a code of conduct that sets expectations for how judges should act in court. If somebody believes the judge's behavior is inappropriate in the courtroom, whether it's an attorney or a member of the public, they can submit a complaint to a commission, the Commission on Judicial Fitness and Disability. The folks on that commission then look over the complaint, and if they decide it is against the code, they'll forward it on to the Supreme Court.
The commission gets a lot of complaints, but very few of them are validated and go through a public process where the judge is found to have violated the code of conduct.
Judge Barnack violated the code of conduct by telling Richard Taylor he hoped he, quote, rots in prison. He also said he thought the community may wonder why Taylor wasn't, quote, hanging from a tree.
This was a very unusual case, and jurors acknowledged, I think, that they were emotionally affected by this case as well.
Judge Barnack's comments came after the defendant declined to comment on his sentences, 21 life sentences without parole, for sexually abusing 2 12-year-old boys. Court officials say the complaint was based on a single incident, not filed on a pattern or practice of behavior by Judge Barnack.
It's not often that a judge violates the code, and so obviously to have your name on TV acknowledging that you made a mistake and that it violated your professional code of ethics is a very serious thing.
I guess that's it. It doesn't sound like a professional news report, and I apologize for I didn't know how bad the audio is going to be, but it's from News 12 in Oregon, and we'll get that linked up in the show notes so people can see that. And so I hate that I have to agree with anything this guy did, but here I think he was right. A child, a guy who sexually abused and raped 2 little boys, should be hanging from a tree. So, okay, so where were we there? You were telling us about the part of the trial, Gabe.
Whoa. Yeah, wow. I did not know about that, Mark. That's crazy. And this is the same courthouse that Barnack was the last judge, and the first judge I had is the one that threw me in the cage for about 8 hours, and all of the people in the jail there were denying my habeas corpus. And so the first judge, I asked him, do I have the right to a fair and meaningful hearing? And I think his response was, you are receiving one, or you have received one. Do I have the right to be informed? You have been informed. And then threw me in the cage. And, I'm not surprised. I'm not sure the right way to say it, but I mean, it doesn't necessarily surprise me that the judges there would get emotional. I mean, and especially given the context of this case. Wow.
Yeah, well, I like how they said that on the commentary on that was that, and that's why I shouldn't have done it, but I couldn't let out because it was ridiculous to claim that judges rarely violate the codes. They do it all day, every single day. They are just on the fact that they're supposed to be fair, impartial, and independent, which is impossible. I mean, like in the video I posted yesterday, well, actually this morning rather, where the judges swear they're independent of the state. I'm independent of the prosecutor of the state. I'm only paid by the state. I only have an oath to the state. I only literally work for the state, but I'm independent. So that there.
But no, Mark. Sorry, go ahead.
But the remark I made in the video on one of the graphics was that, this whole thing about 3 independent branches, that's like saying that the offensive line for UCLA is independent of the defensive line. It's the same team. That's what a conflict of interest means. So I'm doing the video. I'm saying, well, how can I make this as clear as possible so we make the point crystal clear so everyone can understand? And that's the first thing that really came to my mind. That's why I used the football metaphor. It's absolutely astronomical. Oh, yes, the guys on the bench are independent than the guys that are on the field, right? Come on.
And we were discussing a similar topic, that you like these services that this company provides, but how is this company funding these services? Is it on a free market? Are they asking you, or are they taking from you? And if you say no, then what happens? Does the gun come out?
Yeah, the gun comes out.
These are fundamental, simple things that anybody should be able to think about without being offended and feeling the need to resort to immaturity and dishonesty, as we see lawyers and judges do.
Yeah, and this is something we have to keep in mind. You always that's what I say. I can't remember the name of the caller, and I apologize for that. But we deal with a lot of callers here over the years, and he was saying one of the most valuable things he learned from us on the show here was to go in with the assumption that everything the prosecutor, judge, and cop said was a lie and question it. He says it made it so much easier to deal with them because I knew how to respond to pretty much everything they said. And so here what happened to you is more evidence of that. I mean, to turn around and have such heavy reliance on the police officer's sworn statement as being from the hand of Odin himself, and to then not allow cross-examination. So like I said to Calvin earlier, off air, I was even if we accept that the police officer's testimony is absolutely certain and could not be wrong, you still have to allow an effective cross-examination for the trial to be fair. There's no way around that. And so here, I think for your appeal, you should absolutely show the pattern of abuse, which culminated, of course, in the obvious denial of cross-examination, of effective cross-examination. I think 4 or 5 questions would certainly qualify there. So just hold tight. We'll finish in the next segment with Gabe, and we'll be back in just a moment. Don't go away. Welcome back to the No State Project. I'm Marc Stevens. Just because some people were asking me why I pronounced the judge's name Timothy, I'll finish. This is why. I've played it on the show before. I'll have to cut this all out for the broadcast, but I'm just going to play the last part.
Timothy.
Present.
Thank you.
I know that doesn't really explain it, but I put in the chat, and it's the substitute teacher from Key and Peele, and I have to cut it out of the broadcast because I can't post that on YouTube without. And that's why when I put the Louis Armstrong stuff on the show a few shows ago, you can't see the video in Europe because of the copyright. So ridiculous. So where were we, Gabe? Oh, I think we're trying to focus on the issues that you need to raise for your appeal, showing the pattern of abuse that. In which important to point out too, and make sure that you did this. Make sure to put in there that this pattern went through different judges.
Different judges, you said?
Yeah.
Right.
You know, this was a bias that went. It didn't matter who the judge was. The bias in favor of the prosecution was didn't matter. It wasn't dependent on the judge.
Right. Yeah. Is there any other good points you can think of? I mean,
yeah.
The list just of the violations alone would run pretty long. So I'm thinking about which ones I actually want to bother bringing up.
Well, you have prosecutorial misconduct, a Brady violation. The judge allowed the prosecutor to argue without evidence. And I would quote from the Kaczynski's dissent that the only way to stop this epidemic of Brady violations is for the judges to finally, hold them accountable. That the prosecution put a witness on the stand knowing he didn't have personal knowledge of the testimony he was giving. You got a lack of evidence proving jurisdiction. You got a lack of a fair trial because of the bias on part of the judge, denial of effective cross-examination, and then, of course, prosecutorial misconduct. It's a pretty good list.
Mm-hmm. Right.
So that's what I would focus on. All those, each one by themselves, are serious due process violations that should result in a reversible error. It's so serious that it reverses it. And
right, yeah. So I'm thinking right now about doing the appeal on my own. I have some of the text and some of the violations written down. The appellate office sent me their brief that this lawyer had prepared. What do you call it? When you got no money and you got to file the in pauperis or whatever.
In forma pauperis, yeah.
So, but she's of course not willing to challenge the issue of jurisdiction because it's not a meritorious issue.
Well, I do have a template of a brief available, but you still have to make sure, it is just a template, and so you have to make sure your facts are yours. Some of the issues will be the same. You may have to cross over some of the citations, which is not a big deal. And you do have to make sure, because they change the rules a lot, so you just have to make sure that the margins are what they want. That's not a big deal. And typically appeal briefs have to be bound, so you get it like perfect bound, even though it's only 10 pages long, because the rules say that when they open it up, it has to lay flat. Because if you open it and it folds back on itself, they'll throw it out. Yeah, little details like that, but the bulk of the brief and the appendix, I have templates for that, so you can follow that and get it in the right format. They usually make the same errors, and we focus on getting them to make those errors. So if you're not going to do the right thing, at least we've got these standard errors that are pretty bad. So like it says that a finding of reversible error requires one or more of the appellant's substantial rights be affected, or the evidence in question be of such character as to have affected the outcome of the trial. So a substantive right is due process is kind of vague, but a substantive due process right would be denial of cross-examination. Another one is being informed. Those are pretty big ones, so that's why we include those in there. I mean, there's a reason why I hit cross-examination so hard, and that's because it's one of the worst errors they can commit. That's why like I read earlier from Brookhart versus Janus, a denial of cross-examination without waiver is a constitutional error of the first magnitude. So that's why we focus on it. It's one of our strongest. It's one of our strongest tactics, because they actually deny effective cross-examination pretty much every time, and that's why you can tell them, I'm going to say these things, and you're going to deny me effective cross-examination, and they'll just go ahead and do it. Whatever. Wow. If I was trying to scam somebody and they laid out my whole playbook, I think I'd like to do something. I would imagine a smart con man would try to do something different. No, they don't. So, you should be able to, even with, you have to look at each particular area you're talking about and see where it falls under in the pattern of due process violations. So, yours may be a bit longer because you're including, so many statements of fact to support your contention it was a denial of a fair trial. But you should still be able to keep it under 15, at least under 20 pages, which by lawyer standards, that's pretty skimpy.
Right. Yeah, I mean, the annoying part is all the legwork, when you cite a point and you'll probably want to raise 15 points. But again, you yourself only use 3 to 5 points. And I think that's plenty. And you've got to look up the codes that support your conclusion because of this point, and like what should be done because of this violation, and the code that supports that. And you've got to look up appellate decisions and the city code or the state code. And again, this is all undue burdens on somebody who is innocent and unwilling to participate. And the lack of ethics these people have is never surprising to me, but it is usually shocking still to think of how inhuman these people can be. But
yeah.
So in speaking with the appellate attorney, one of the things she pressed hard was that I can either go forward with the supplemental brief with the brief that she has done, and I can file up to 5 pages of a supplemental brief challenging additional issues that she didn't, or I can do my own brief and just dismiss her. But I am wondering what your thoughts are. Like, I was thinking that if I do a supplemental brief with a lawyer representing me, then my supplemental brief is going to carry basically no weight.
I don't know if it's accurate to say it's not going to carry any weight. They should consider what you've put forth. And that's a decision.
Right.
They should put, but you said it was limited to 5 pages?
I believe it's 5 pages
Wow.
for supplemental brief.
Well, hold on a moment.
So she wants to...
We're up against the break, so just hold on. We'll finish this in the next segment. My name is Marc Stevens. We'll be back in just a few moments. Don't go away. I blew that one. We are in the last segment here on the No State Project. It goes fast. And appreciate the comments from the No State Project Skype chat, and invite everyone to use the link on markstevens.net on the upcoming events to do role-playing in the chat. Get into the chat and then go into, you can be brought into another room to do an actual role-play, which is voice, which has been very, very helpful. We've had a lot of people, even if things did not go well in court, that it was valuable to have the role-playing and go over the tactics. So welcome back, Gabe. I'm sorry, I did not write down where we were, so you're going to have to bring me back on point.
Sure. We were discussing a 5-page supplemental brief versus filing my own up to 35-page brief.
Yeah, I actually did write it down. I couldn't read it.
Oh, okay. Yeah, I have that same issue.
Oh my gosh, that's a 5. That wow. It looks like like Sumerian writing at this point, but okay. Oh, well, obviously it's up to you. I would say that you can probably still get it done in 5 pages as long as you don't have to find out if you have to follow the same rules, because if you have to follow the same rules for your supplemental brief, you can't really do it in 5 pages, because there is a table of contents and there's citations and you have to have a table of citations. It doesn't leave you much room to do a formal brief. So find out. And so if you don't have to follow the rules, if you could just basically lay out, then you should be able to do that in 5 pages. So you don't have to have a separate page of citations. You can just have the citations in the body of the in your argument. So I mean,
right. I believe that would be correct.
Yeah. So if you can do that, then yeah, I think you should be able to get it in 5 pages.
Okay. Yeah, I guess I'll have to start thinking about that more, because I was really planning on dismissing her and filing my own, because she wants to challenge denial of cross, even though it was really denial of effective cross. I believe, if I'm not mistaken.
Well, I think she's right.
4 questions in.
4 questions in, you've been denied cross. If you had gotten 20, 30, or 40 questions, then, but you weren't allowed to question him on the really important stuff, like the evidence supporting his, claim of probable cause, then it's more accurate to say denial of effective cross. But here, yes, I think you have almost a wholesale denial of cross. You're still technically being denied an effective cross, but you're being denied a cross-examination. So I certainly wouldn't falter for that. That's accurate. So if she's raising really good issues, then it may be worth, and maybe, I don't know. I haven't seen it. So, but if she's making that argument, I think that's pretty good. You can't fault her there.
That's the strongest one she's making. The other ones is denial of opening and denial of closing statement, I believe, is the only other issues she wants to challenge, which to me is ridiculous.
Yeah, that's kind of weak. I could see denial of close. But let me ask you to remind me, when the judge stopped your cross-examination, did he give you an opportunity to put on a case after the prosecution rested?
No, I don't believe so. Well, he asked me if I wanted to testify, and...
Okay, so...
I don't know, where were you going?
Well, usually what happens here, and I've been the victim of this a lot, where they end the cross-examination because they're very upset with you. Not that they're yelling and screaming, but they don't like what you just did. And so in anger, they end it right there, and they say, if whether you have closing arguments or not, we're done. And they don't give you the opportunity to put on a case. But here, you don't have that option, because he pretty much allowed you, he asked you, you could have said, well, I'm not going to testify, but I'm going to recall the cop. And if he told you to get bent, then you have a denial of him allowing you to put on a case. That's pretty bad.
Interesting.
That would be pretty bad. That's why I always tell people, don't worry if they turn around and tell you that you're guilty after you've done the cross-examination and the prosecution arrest, and they go right to conviction. They just denied you an opportunity to put on a case. Pretty bad. Pretty.
Mm-hmm. Yeah, we'll have to, I'm sorry to have monopolized all your time. If there's any people listening who wanted to speak with you or had questions, I definitely encourage you to get into the Skype chat. We talk about these issues all the time, and most of the questions we hear are pretty easily answered. I can't encourage joining the Skype chat and actually doing some role playing yourself enough, because it is incredibly important.
It's like, hey, it's the difference between learning from a book how to play guitar and actually putting your hands on the neck and playing, or like boxing. You can learn and be taught boxing in a classroom, but it doesn't do you any good until you actually get in there and do it. And it should be like martial arts or boxing, where it's a part of the way you communicate now. You don't have to think so much about it. You know how to respond to this crap. Very little of what a bureaucrat will say to me, and I promise everybody we're going to be doing a lot more call to shames. A lot more. I've done it for so long, it's just so automatic. You just get to know how to respond to them. And that's why it helps, of course, like I mentioned, just assume what they're saying is a lie, and you ask them questions to get them to verify that their claim is true. You got to do the role playing, and only a couple people have sent me videos about the city council meetings, but no one's really. I don't know if the ones I've seen are not. They're just not asking the questions right, and you have to be very clear in your questions to be able to, in your leading questions, in order to effectively. Not cross-examine, but effectively discredit somebody or bring out the contradictions in their claims. You can't drop the ball there, and so the role playing is very effective for that. And but when you go into the city council meetings, you got to be very, very clear. Hey, I know you operate under the presumption that if I'm physically in Oregon, your laws apply. Yeah, okay. Do you have any proof that that's true? Any evidence that proves that's true?
Yeah, effective Socratics requires lots and lots of time in the seat, lots of practice. And the issue you had brought up was to assume every word that comes out of their mouth is a lie, because it probably is. I bet money on it, and it'd be a safe bet. But this gets through to probably 60% of people. And then you've got to find other ways of getting it through people's skulls. That's why we go over so many of the red herrings. And ultimately, after you've gotten through every red herring that they can throw up as a defensive wall, then they're left with no quarter. And either they have complete cognitive dissonance and they go into a mental home, claiming that Santa Claus and states exist, or they come to your side and say, I don't know how I was fooled all those years, but they did it, and now I see the light.
Yeah, I would point out, too, because, my wife is she really doesn't like confrontation or, even though we love The Office, she's one of those people that cannot watch Scott's Tots. She can't, because it's too uncomfortable. So she can't even watch the British Office, because it's even better for the uncomfortable situation that they're exploiting. And I think that plays into it also, because you look, some of us actually have empathy, unlike these lawyers. We care, and I can feel how uncomfortable people are getting when you're asking these questions. It's just like people reported that Socrates made people just melt, that they wanted to just crawl under a rock. And because what you're doing is you're exposing them right in front of their peers, and that's very uncomfortable, and we experience that. But the role-playing and whatnot helps alleviate some of that. You still have to ask the question, even if the other person is finding it extremely uncomfortable because you're exposing them as a fraud, which we can, all appreciate. Hey, I appreciate the call. My name is Marc Stevens. You've been listening to the No State Project right here on LRN.FM, the Liberty Radio Network. Yeah, and welcome back, Theron. We just heard from Theron. I'll contact him off air. Good to have him back. We will be live on Wednesday, so till then, salud.